But I just wanted to read out some statistics about domestic violence, just in case you didn't know. And it's really interesting, I think, for me, that I planned this show about 4 weeks ago, and I didn't know that domestic violence would be a topical issue this week on other radio stations or in the media in general. And I guess, raising the awareness of how many people are suffering, and it's not only women who are suffering, and I want to point that out. It's not only women who are suffering, but majority of the people who are suffering from domestic violence are women. So just to put that out there, so nobody thinks that I'm only focusing on women, but majority of the people who suffer from domestic violence are women. So here are some statistics for you. 2 women are killed every week due to domestic violence in the UK. It's estimated that 1 in 4 women will experience domestic violence at some point in her life, which is a bit scary. There are 3 of us in the room now, so potentially 1 in 4 by the time the other guest gets in here could suffer from domestic violence in our lifetime, which it's kind of scary and it's creepy. 1 incident is reported to the police every minute. Domestic violence and any other abuse is common. It's a common cause of depression and other mental health issues or mental health difficulties that women suffer. So those are just few of the statistics. If you think about it, there's also more that 50 to 60% of patients using mental health services are affected by domestic violence, and over 20% will be currently abused. I'm not going to go on because there's a lot more statistics to read out to you, but I think you get the general gist of what we're saying. And if you know one person who's been affected by domestic violence, or if you have been affected by domestic violence, then you know how devastating it is to you and devastating it is to the person who's experienced it. But I think for those who don't know what the law considers domestic violence, I don't know if you Mavis could tell us what the law considers domestic violence now.
Well, the question of a definition of domestic violence is an interesting one. I think those of us in this room, people listening, will all know perfectly well what we mean by domestic violence, and I'm sure all of us mean a lot more than just a black eye or a broken arm. We mean the psychological pressures, we mean the social isolation, not being able to use the phone to speak to your mother, your sister, your friends, just relentless pressure, what is beginning to be known as coercive control, which goes right beyond any kind of physical violence and encompasses all the psychological issues as well. But at the moment, domestic violence, the definition is important because it's used, there are different definitions being used by different government departments for different purposes. And what's happening is that with the financial austerity, with all the cuts in public services, domestic violence is becoming the kind of passport to getting all kinds of help.
Oh, really?
And in particular, there are 2 issues. Stop me.
No, please go on.
There are 2 key areas where this is becoming really important. One is the question of applying for maintenance for your child. The Child Support Agency. There are plans to require women to pay to have an assessment made of what the father of their child should be contributing to the child's expenses of £100 or so, and you'll be excused that payment if there's a domestic violence issue, but they haven't yet decided how to define domestic violence. And the same thing's happening with the legal aid changes. Legal aid for help with matters about contact with the parents of your child and where the child will live. All of that will go in a year's time unless there is a domestic violence issue. And it's not going to be enough to identify yourself as a victim of domestic violence. Under the legal aid plan changes, it's not even enough to have evidence from a doctor or a neighbour or a witness, you're going to have an existing order, so that a court must have found there to have been domestic violence. So that's why the question of a definition is important, and every government department has a different one.
I'm trying to understand why would different departments who are under the same government have different definitions of what domestic violence is? Because if like you said, domestic violence is not only a black eye, it's not only bruises on your arm or the psychological hurt that you feel. Why wouldn't that be a standard definition as it is? Why wouldn't that be standard right across everywhere?
Partly, well, if we go back to the family court, start there, where you've got arguments about whether, for example, a dad should be able to see his kids without anyone else there, whether he should be okay to have them for the weekend or
supervised or non-supervised.
Non-supervised. You're entering into quite a conflicted situation, and there's a lot of concern. I'm sorry to talk in gender terms. It's not always simple, but for shorthand, Dad can say that Mum doesn't want him to have the kids just because she doesn't want him to have the kids, and that she's alleging domestic violence, but it's all in her head. It's all just part of the battle. So a court will, I think it's reasonable for a court to look for some form of evidence, but of course it's an area where evidence is very, very hard to find, and the only really tough evidence which a court can see is an order made by another court. And before the government's going to hand out this quite extensive funding for legal aid, legal advice, legal representation, they're looking for a pretty tough definition of the existence of a problem.
So, Kate, from your own perspective, this definition of domestic violence, and we haven't said this, but there's a consultation going on which ends next week, Friday on the 30th, that's looking to change the definition of domestic violence. How has that affected you, Kate, as a family lawyer?
As a practitioner, sort of on the front line of trying to help generally, as we were saying, generally trying to help the women and children, the definition of domestic violence that's being considered through the government departments doesn't affect us so much. There are two orders that you can apply for, and as we were talking about, legal aid is one of the elements that would assist with that, to protect yourself from domestic violence in the form of an occupation order and a non-molestation order. And neither of them, which no doubt we will come on to discuss a little bit later on, but neither of them require this definition, particularly the non-molestation order. Molestation has been defined as really being very broad. There is no set definition of non-molestation, and it can include pestering, it can include more of a harassment role. So it's very much wider than simply what we would perhaps expect as we were saying, a black eye or violence. It doesn't need to be violence in order to be able to get these orders. And what the court really looks for is whether there has been a significant risk of harm, or whether there is a significant risk of harm to either the adult applying or the relevant child, which no doubt we'll come on to a little bit later as well. And harm is defined as really very broad. It can be mental harm, physical harm, emotional harm, any type of harm that puts the applicant at risk. Will not necessarily guarantee, but will satisfy the court sufficiently to be able to apply for an order. So at present, in terms of this definition of domestic violence and where we are on the cliff face of protecting our clients, there does seem to be this sort of difference in terms of what they're trying to define, because for us it's already there. If we have clients in front of us and they satisfy the the test, if you like, for the fact that there is a risk and there is harm, then we would go ahead and make the application on their behalf. We tend to find that we're more restricted, not necessarily with the definition of domestic violence, but in the list of people who are able to make the applications.
Okay.
When you make the application, you have to fall within the list of what's referred to as associated people. Generally, and this is not exhaustive, it tends to be relatives, if you've been married or are married, if you've lived with someone or are in a significant relationship or have children together. Generally, that's not an exhaustive list, but if you are one of them, you fall within the category to make the application. We come across far more difficulty, not necessarily in terms of the definition, but in terms of if you're not one of those people, then what sort of protection do you get?
I guess now we can bring in our former Crown Prosecutor, Funmi Johnson. Welcome.
Hello, thank you for having me.
Oh, you're welcome. It's a pleasure to see you again. Disclosure, Funmi and I are friends. We've known each other for a long time. But you worked in the Crown Prosecution for how long?
Gosh, a long time.
Okay.
Working on domestic violence issues primarily from 2003 onwards.
Okay. And just listening to what Kate has said, I guess we're looking at it from the other point of view where you would have to prosecute the abuser. What would you say about the definition of domestic violence and how that affects the way you can prosecute people?
I think it was more problematic previously, before the changes to the Criminal Justice 2003 Act, because what women were telling us repeatedly was it's not just a one-off incident, and the police were taking the statements. There was a lot of history involved in the statement, but as a prosecutor you were saying, well, actually I'm only dealing with the case that's taking place on this particular date because that's the charge that he's being charged with. And so it was quite difficult to get in previous incidents of violence in order to try and contextualise the offence that we were looking at, because the risk then of not contextualising it is it looks like a one-off piece of behaviour. It's usually presented as a one-off piece of behaviour, whereas we know that actually there's been a history of controlling and coercive behaviour that's given rise to this particular incident that's being charged. So there was a case back in 1999 that said that you could introduce previous behaviour, even if it hadn't been charged, as long as it went to contextualise the offence. But the Criminal Justice Act, the hearsay provisions, helped us to be able to bring in previous incidents of behaviour that could go to a fact that was being dealt with at that moment. So we could bring things in, but obviously there were laws, there were rules to adhere to, and you couldn't just bring things in as you wanted to. You had to follow the rules to make sure you fell within the category.
Just listening, did you want to say something? Just listening to that, it strikes me that a woman would be scared to even go down that road if it's just the one incident that's going to be taken into account, even if she's reported it to the police a couple of times, but she hasn't brought an order against the perpetrator. So she would, and if that's not going to stick, then she would still feel that she's under she could be under attack again. Mavis, you're nodding.
I'm nodding away. And the other sort of sting in the tail of the legal aid changes is that the person who's being accused of the violence may not be legally aided, which means that in the course of a hearing, if some evidence is being tested, if a woman is saying various things have happened, and he wants to question her account of what happened, he will now be able to directly question her in court.
Oh, really?
This is something which can't happen in criminal proceedings. You're protected from being
facing your attacker,
as a victim by the person who is accused of attacking you in criminal proceedings. But because most domestic violence cases are civil cases, not criminal cases, this could happen after the new legal aid changes come in next year, which I think is absolutely outrageous.
That is disgusting, I have to say.
Issues here. I think everybody's agreeing.
Yeah, I mean, I think everybody who's listening would agree with that, because I can't imagine that and I had the statistics that it takes 30 30 or 35 attacks before somebody will report a domestic violence. And if that's the case, so you've been through the trauma and you finally got the courage to report or, do something about it. And then you still have to face your attacker, and your attacker has to question you and probably use, emotional blackmail, because the reason why he's been, or the person has been attacking the victim is because you wanted to demean the person. So they will already have intimate knowledge about the person, secrets, and use all that to taunt the person. Go on,
I think the thing to remember about domestic violence is that it's still a very hidden crime, in the sense that there are ways that the perpetrator can influence the behaviour of the victim that's not immediately apparent to the bystander. So, for example, there might be specific words that are used, there might be specific phrases that are used that have particular meaning to the victim and the perpetrator, and once they're said, it has the effect of shutting the victim up.
Wow. That's a whole lot more serious than I thought. What you were going to say?
I think also just one of the things that we're talking, just to make the clarification today, is that when we talk about orders from the protective point of view that you would go and see a family lawyer about, that is very much a civil remedy. So it doesn't go through the criminal courts, and that's where you would have quite potentially, as we've been telling, that if these changes do come into the legal aid system, you could quite possibly have a perpetrator cross-examining the victim, who would no doubt be our client, if you like, within the courtroom. But just to really reassure the listeners, there are steps that can be taken within the family courtroom. First of all, it's a closed courtroom when you have civil proceedings in terms of family, which means that no one else can come into the proceedings. So it's not a court when you might imagine, for example, the criminal court where you have the public gallery. It's not that. It is quite literally the judge, the parties, and if there is available, their legal representatives. But we can and do take steps. I've often made arrangements with the court that if that was going to happen, knowing that the respondent, as they're referred to in family proceedings, is going to be attempting to cross-examine my client, then you can put things in place. For example, my client may be giving evidence behind a screen. So although they are there cross-examining them, which does happen, at least there is that break between them. They can't actually see them. And there are times where we're not allowed to speak to our clients, we're not allowed to encourage them in any way, but we can sit behind that screen with them. And for example, if we got to that stage, we may be instructing a barrister to put the case forward. The barrister would stand before the judge as normal, and we would be able to sit with our client behind the screen, just as a sort of a reassurance thing, rather than, obviously we wouldn't be able to guide them in their evidence. But there are steps that can be taken, but that doesn't get away from the fact, and it certainly doesn't assist the fact, that we have this situation in the first place.
You were going to say something, Mavis? No?
Well, I was just thinking, I think you were talking there about what happens in an actual domestic violence case, but of course domestic violence is a factor and is part of the context in other cases, particularly contact disputes. And that's the area which I should say again that I'm a trustee of Maypole Women, which was set up to try and support women experiencing difficult contact and residence cases where there were domestic violence issues. And if the violence is part of the discussion about what kind of contact is appropriate, then the woman may well not have you sitting beside her and reassuring her. She may well be on her own. So it's the power imbalance is not a comfortable one.
Yeah, I think yes. You're going to say.
Sorry, I was just going to say. Aside from that, I think that domestic violence, although it is still very much a hidden issue, people don't like talking about it. particularly women, if we're the victims of it, a lot of the time, to be absolutely honest, and I know that a lot of the listeners would agree with this, we're just very proud. It takes a lot of courage to admit, even to our friends or closest family, this is what's going on. So people do.
There's a shame attached to it, isn't there?
Yes, as well. And if I admit it, then that's a step forward, but it could be seen as a step back because I'm admitting that this is what I'm putting up with. Yes. But it is something that the courts are becoming increasingly, especially the family courts, are becoming increasingly more aware of. And when we do have cases, particularly with children, that no doubt we'll expand on in a minute, the judge is very protective of the clients in front of them. And if there was who would no doubt be a mother in that case, if there was a mother before the judge who wasn't being represented, the district judges are very hot on things like this. They will take steps to protect the mother in those circumstances. It doesn't get away from the fact that we're in that situation already, and no doubt we're going to discuss more about the horror of that, quite honestly. But the court does recognise it, and there are courses that the district judges can order that the father, if it was the father in this case, can attend before they get any contact with the children, depending on the level of the domestic violence, the type of it. They can attend courses such as...
But when you say the level of domestic violence, should it be a level? It's domestic violence full stop? You know, should it be a question of, he was really bad, or he wasn't so bad, or he was his first one, so we shouldn't be so hard on him, or is his 30th one, or whatever? You're going to say for me?
I think there are so many things to be balanced, unfortunately, and finances are always things that come into the balance. And when we're talking about courses that particular perpetrators can go on, there was some really good research about the different types of perpetrators. There are those who will respond to the sharp shock of being arrested, and they will go on a course, and they will maybe not necessarily stop all the violence. They may change to a different form of violence. The violence may reduce. Some may stop. I don't know if some will or some won't.
Have you ever experienced that in the work that you've been doing, that you see that there isn't any case of domestic violence anymore?
Speaking as a criminal prosecutor, the work was repeat work, so you saw the same people over and over again, so I would have to say no. But then you have to remember that there's the majority of perpetrators haven't come into contact with the criminal justice system at all. They just don't get into the system because no one brings a report, understandably. But there are always competing issues in whatever field you're in, and I think that district judges have to make a decision about, well, based on what's in front of me, this person looks like they could be suitable for this kind of course. And most commonly it would be a domestic violence intervention kind of program, which is actually quite rigorous. Most people think, they've just got a smack on the wrist and off you go. It's a very rigorous program that's really designed, and I think the reason why it tackles behaviour is because it goes to the heart of the behaviour and makes the perpetrator face the behaviour, understand and recognise that what they are doing is exerting power and control in order to make the relationship what they want it to be. So there are those perpetrators who will respond to that, and of course there are others who won't.
And there are two stages to many of what we refer to as a DVIP course. There are two stages to many of them. So, for example, they might run over quite a significant period of time. Some of them run up to 52 weeks. Some of them, which is quite significantly. The first half of them is often facing the domestic violence, which is why the district judges often have to weigh up, are they actually going to respond to it? Are they going to engage with it? Because in order to get to the second half of the course, which is when they then deal with the domestic violence, they have to pass the first part of actually accepting that that's what they did. And a lot of perpetrators simply don't make it through the first half of the course because they're not willing to accept, actually, this is what I've been doing. And in contact cases, that can result in them therefore never progressing the contact. The whole point of the assessment is that they go on the DVIP course, and as a result of that, we will then consider whether the contact is suitable in whatever context. It could be indirect contact, it could be letters, but even that may not be appropriate if the perpetrator isn't even willing to accept that they caused the domestic violence in the first place.
So at this point, this is when there's been a separation and they're not living together. Am I correct in thinking?
Not necessarily.
Not necessarily.
Oh!
It's quite... You have to have the possibility of funding another place to live. It's not so easy. And the other... we've been talking about women's reluctance to talk about domestic violence. Very often there's real love and affection, and there's no wish to see this man punished. All they want is for him to be his old lovely self. And why has he got so angry? Why does he drink? Why does he resort to physical violence? They want the behaviour to stop, and they don't necessarily want to end the relationship or live apart.
That's interesting. You were going to say.
Sorry, I was just going to add on to that. I think certainly from a practice side of things, with my experience, there's also a lot of part of the domestic violence that we don't see and we don't get bruises from is the control element of it.
Yeah, I was just going to get into that. Yeah.
Perpetrators are very skilled at keeping that love alive, and yet very subtly chipping away at generally women, and apologies for the generalisation, but chipping away at the women so that they're in this unbalanced situation of believing, as we say, very much that they love them because they're their partner, they're very loving, and they can be the perfect partner. It's the occasions when they do snap. And we also need to remember that sometimes domestic violence may happen once, and then there will be a period when it's absolutely fine. They apologise, they say they love them, let's move the relationship forward, it will never happen again. And because of that belief that we want the relationship to continue, it does continue until the next time, and then the cycle starts again. So I don't think that we can underestimate the effect of that control that they have on generally ladies.
I would very much echo that, because there was a very good advert run by Women's Aid a couple of years ago, and it was two sofas. The cushion was on the right-hand side in one and on the left-hand side on the other, and it said, put it on the left and he will hit you, put it on the right and he will hit you. And what it was trying to get at is that the perpetrator is in control of their behaviour. They choose to use violence. It's not something that suddenly happens and overcomes them. It's not a spur-of-the-moment thing. They absolutely choose when, where, how much violence to use, when they will use it, what they will use it for. Because if you think about it logically, if people were really out of control, there would be much more than 2 murders a week. They would just start and they wouldn't know when to stop. But actually they choose. They choose when to start, they choose when to stop, they choose what offence you've committed that the violence should follow for. So it's very much a very controlled set of behaviours. It's not uncontrolled, it's not out of control, it's very much in control.
It's very calculated on their behalf.
I think at this point, we've talked about what the government did, this consultation going on, and they're looking to include coercive control into the definition of domestic violence. And I'll just read out some of the options. So I think everyone needs to go and take part in this consultation to make sure that it becomes law. I think after reading all this, I hope you'll be motivated. So the option, I think when a consultation is being put out, there are different options that they have to go through. So one is, does it have to remain the same? So i.e. the definition of domestic violence wouldn't include coercive control, and that's the first option. So then the second option is the definition of domestic violence is amended to include coercive control, and this option asks your views on whether the cross-government definition should include the words coercive control. Coercive control is a complex pattern of abuse using control, which we've just been talking about, and psychological control over financial control, verbal abuse, forced social isolation. And then the third option is to extend the definition to include 16 to 17-year-olds, and this applies to those under 18 into the definition, because I think up until this point it's not included. And I think the fourth one is extending it to under 8. I think it's a repeat of the first one, under 18-year-olds. And I think if you know young people who are in relationships and they wouldn't understand that what they're going through, which is mostly coercive control in a lot of cases, they wouldn't understand that that's part of domestic violence because they're young. They don't understand that it's not when he hits you that there's that it's violence. It's all the other things, isolating you from friends, from family at the same time. For me, you were going to say something.
I'm just interested to find out what the purpose of adding in the words coercive and controlling would bring to the equation, because the current definition actually speaks of any incident of threatening behaviour, violence or abuse, psychological, physical, sexual, financial or emotional. And that is what the whole phrase coercive control is getting at. Yeah. And I just wonder, we have to be so careful to not use language to alienate people. And whilst we in this room and people listening to us might have some understanding of coercive control, there might be others who don't, and so will wonder even more whether what they're facing is abuse. And I suppose I just wonder, from wearing my criminal prosecutor hat, well, how's that really going to help me? Are you going to change the law as well, so that I can then, be sure that I can bring in every other incident of behaviour to show the pattern of coercive control? I suppose I'm just a bit confused as to what it's supposed to add by having this phrase in.
What would you say, Kate, to that?
Certainly, I have to say that I agree. From the practice point of view, for practitioners and clients obtaining and applying for non-molestation orders and occupation orders. And just briefly, a non-molestation order is an order, if you like, that stops the perpetrator and prohibits them from using and threatening violence, from talking to them in a controlling manner, it can even go so far as to stop them contacting them entirely. It can stop them entering or attempting to enter a property. It can stop them going to the schools quite frequently and a distance from it. So it may be entering or attempting to enter the property or the school, or go within 50 yards of it. So it's quite a wide reaching order, and an occupation order is one that regulates the terms of the house, and there are different sections which apply to different clients and their different situations. Perhaps you have an interest in the house, you may own it, perhaps it's the matrimonial home, perhaps you're a cohabitant, and there are different rules that apply, but it regulates the occupation of the home. So for example, you may have an order that says your client can remain there, and the perpetrator, or the respondent in our terms, must vacate the house and stay away from it. So they do go hand in hand. And as I was saying earlier in the show, we're not bound by this definition of domestic violence in order to obtain these orders. It already encompasses harm, which is already emotional, physical, mental, controlling behaviour. In terms of the practice side of it, I agree entirely, because are they going to fundamentally change the Family Law Act, which is where the statute that allows us to make these applications? Because it doesn't appear to add to it. We don't need that definition to make the application.
Yeah. I think what it is trying to do is move away from the stereotype of domestic violence as being physical violence. We did some research quite recently. We've been talking now about different definitions used by different government departments. There are different definitions used by the caring professionals, the helping professionals. And we did some interviews with mediators, with solicitors, and solicitors who specialise in child protection, and health professionals. And they all use themselves different definitions. And it was the mediators in particular were looking for physical manifestations. Sorry.
Are you all right? Yeah, we're going to take a short break. Yeah.
I think it's just to change the message and get away from the physical.
Yes, you're going to say.
But I think I wonder how much difference that will make, because we're talking about people's practice. And at the moment, it's not mandatory to use the definition. It's best practice, and it would be good. And certainly in the Crown Prosecution Service, the police, there was training around using the same definition so that when a case was presented, the police knew what to present and the prosecutor knew what to expect. But really, it's about the responses that women get when they do find the courage to report, when they go to individual agencies. It's around how are they met by the people that they are disclosing violence to? Are they being met in a very dismissive way, being told it's not violence because there is no physical abuse? Or are they being met by people who are simply afraid to engage with the issue and so will send them away anyway? So really, for me, it's more about educating people about what domestic violence is, rather than really worrying about so much what the words of the definition say.
Yeah, I can see that. We'll come back. We'll come back to that in a short while. We're going to take a little break. We're going to listen to "With or Without You" by U2. I love this song. I know I keep on playing it almost every week, but bear with me, people. Back with you in a little while. Welcome back to Dream Corner. My name is Oyolu, and we're talking about domestic violence. I have Mavis Mclean, and I have Funmi Johnson, and I have Kate Smith here, giving their very useful and valuable input into this topic. I think just to close off round of what we were talking about before we went to break. You were saying for me that the reason why or was it you, Mavis, saying that the reason why it's important to include this definition is because women can have, when they're making applications for maintenance, that is easier for them if the coercive control is included in the definition.
Well, my concern is that for years we've been trying to encourage women to disclose domestic violence. We've been trying to have it considered as something which is endemic in society. It's not shameful to talk about the people perpetrating it are in need of help. This is something to be talked about and dealt with. And suddenly we're turning our backs on all of that and saying that domestic violence is only now really a policy matter for government in terms of being a passport to things which cost money, i.e. under the Child Support Agency, which in the past would help women discover what sort of amount their husbands, ex-husbands, ex-partners could be expected to contribute to the child. Now, if they want to have that calculation made, they're going to have to pay £100, and they will be excused that £100 if it's a domestic violence case, but they haven't quite decided how to define it. And similarly with legal aid, the domestic violence will get you the legal aid, will get you the free child support assessment. It's no longer something which is to be helped with, to be dealt with. It's just becoming a kind of ticket to other services, which I think is a very retrograde step.
Yeah, you're going to say for me.
I think it's one of those things where the intention is right, but the result, the unintended consequences are probably not what one would want. And the example that always comes to my mind is when France passed the law about women wearing a burqa, not being able to come out into the public space. On the one hand, that seems like quite a positive thing to do. You're saying that you recognise that for some women, I can't say all because some women may have chosen to wear the burqa. For some women, it will be an opportunity for them to have their rights recognised, to say that they don't want to wear the burqa and therefore they want to be able to come out into the public space without it. But that ignores the fact that actually, if it's not your choice to wear the burqa in the first place, it's hardly going to be likely that you're going to be able to make the choice to not wear it in a public space. Therefore, what that means is that you are further marginalised within society because you're then not able to go out at all because you can't be in a public space. Otherwise, you'll be fined. Where do you get the money to pay the fine if you've been kept at home, you're not allowed to work? The financial control. So it's one of those things that on the surface it looks like a good thing to do, but the unintended consequences, and particularly for a woman who's experiencing violence, to further render her invisible by saying that actually something that you chose not to do in the first place is going to give rise to legal liability for you is actually quite a damaging thing to put forward. But like I said, it's probably an unintended consequence of what was a very good intention. And my concern, like Mavis, is the unintended consequences of using the definition as a gateway